Hello friends, in the series on income tax cases, today we will discuss a very important issue in regard to section 50C. The issue before the Honorable Bombay High Court in the present case was that whether section 50C will be applicable for those land and buildings which are held by the assessee not in the capacity of as owner but as a lessee or by any other mode. The issue has been decided by the Honorable Bombay High Court in the case of Vidarbha Veneer Industries Limited versus Income Tax Officer, and this case is reported in 484 ITR at page number 132, and the date of the judgment is 1st April 2025. In the present case, there was a dispute regarding the 4 lands which has been transferred by the assessee to some other person, and the consideration was less than the circle rate. In the present case, the assessee has got these lands by way of assignment, and from the person from whom the assessee has got these lands from as an assignment, that person has got those lands on lease. When the assessment proceedings were going on, the learned assessing officer was of the view that since in the present case the sale consideration is less than the circle rate, so section 50C is applicable and so the assessing officer made the additions into the income of the assessee accordingly. It was the submission of the assessee that the land which has been held by the assessee are not held as an owner but they were on lease, so section 50C is not applicable. Even the tribunal held in favor of the revenue that the section 50C will be applicable even if the land is not held by the assessee as an owner but if it is held by the assessee as a lessee, even in those cases section 50C will be applicable. The assessee paid before the Bombay High Court, and when the matter was heard by the court first of all said that section 50C says that when the consideration received by the assessee is less than the circle rate because of the transfer of a capital asset, then in that case the circle rate will be considered as consideration. The court said that the definition of the capital asset is given in section 2 clause 15, and the section 2 clause 14 mentions that any asset which is held by the assessee, the court said that in section 2 clause 14 the language does not say about ownership but if the asset is held. The meaning thereby that according to the court, if the asset is held by the assessee, even not by the way of ownership but by way of lease, then in that case section 50C will be applicable. The court said that the asset is held by the assessee in the present case as a lessee and not as an owner, even then section 50C will be applicable. The court said that holding can be either by way of owner, lessee, sublessee or as an allottee or any other gratuitous licensee. So the manner of holding is not important. What is important is that there should be transfer and there should be capital asset in the form of land and building. It does not matter whether the asset is held as an ownership or as a lessee. The court said that the transfer what used in section 50C subsection 1 does not and should not be used in a very restricted sense, and it covers all the transfers whether it is by the lease or by any other mode. Friends, this case is very important because in a number of cases some tribunals and some courts have held that section 50C is not applicable in case of lease properties. So this case is a little bit harsh for the assessee, but the reasoning which has been given by the court is very well reasoned order, and in this case the court has linked section 50C with section 2 clause 14 which gives the definition of the capital asset. At the end of this video, once again I am repeating the name of the case. The name of the case is Vidarbha Veneer Industries Limited versus Income Tax Officer, and this case is reported in 484 ITR at page number 132, and the date of the judgment is 1st April 2025. Thank you, friends.